The Supreme Court on Friday declared the Executive Order 10, which President Muhammadu Buhari issued on the funding of the state judiciary and legislature, illegal. The top court, in a split decision by a 7-man panel of justices, held that President Buhari acted beyond his statutory powers. The judgment followed a suit that was filed by 36 states of the Federation. While 6 justices upheld the suit, a member of the panel dismissed it. It will be recalled that President Muhammadu Buhari had, in the executive order he signed on the 22nd of May 2020, made it mandatory for all states to include allocations of both the legislature and the judiciary in the appropriation laws, in compliance with Section 12, subsection 3 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Now, joining us now to discuss the latest developments in Nigeria's quest to strengthen the institutions of the legislature and the judiciary at the subnational level is Dr. Kunle Ojo, a senior advocate of Nigeria and a former vice president of the Nigeria Bar Association. I want to say thank you very much for joining us here on Newsday. And right now, a lot is being made about the decision from the Supreme Court or the Apex Court here in Nigeria. Talk to us about it. At the moment, the presidency have their own side, and it seems that the justices are on the other side. Talk to us about it.
Well, I think that's the beauty of democracy, and ordinarily, the judicial arm has been placed in a position to be a check on the executive and be a check on the legislative arm whenever they go astray. But having said that much, the executive order ordinarily could be made by the president, because our presidential system of government is fashioned fashioned after what is obtainable in America. And given that scenario, it's good enough that we have a president that is taking that is utilizing this window of opportunity in making executive orders. But unfortunately, this executive order number 10 doesn't seem to be good enough. And a good number of us, we spoke about it in the past. In fact, long before the judgment of the Supreme Court, I've had cause to talk about this on few occasions. And sincerely speaking, the fact that you can validly make executive order does not empower you to make executive order that is at variance with the Constitution, that is a subversion of constitutional democracy. And if that is done, then definitely the judicial arm, that is the judiciary, can legitimately declare such executive order invalid, and that is what the Supreme Court has done in this wise. And if you look at it very well, the executive order was made to strengthen Section 121, subsection 3 of the Constitution of the Federal Republic of Nigeria as amended 1999. It is, if you look at that section itself, it is self-executory. It does not require the intervention of the presidency, the president. It doesn't require his intervention. It doesn't require the intervention of the Accountant General of the Federation. It does not require the intervention of the Attorney General of the Federation in any way. So, because it's clear, the law is clear, the constitution is clear, it doesn't warrant the making of the executive order. And if you look at the executive order made, it is not suitable for federalism. It will mean that the president will be determining what happens in the states of the federation. Yes, because the law itself is good enough, there is autonomy for legislative arm, for the state houses of assembly as we speak now. There is financial autonomy for the courts in the states, because it says clearly that whatever money that is that is for the credit of the respective houses of assembly, for the respective courts of each state, because they draw their money directly from the consolidated revenue allocation fund. Then let it be given to the head of, for example, for the head of the judiciary of the state. And that's the position of the law. And by the time we now bring in the Attorney General of the Federation, the Accountant General of the Federation, to now start putting some punitive measure in place, that's not the law. So apparently, I think the Supreme Court decision is in order, and it has helped us to number one, strengthen our democracy, and number two, prove that we are operating a federal system of government, and each arm, that is the states ought to be respected, each tier of government ought to be fully respected.
Dr. Ojo, thank you for that. It said you mentioned that it did not require the intervention of the president, this Executive Order 10. I'm wondering, and I think a lot of Nigerians wonder as well, what would be the reason that the president would put forth such an executive order that would end up getting shot down by the Supreme Court anyways? Is he not maybe getting the best advice?
Well, I won't say that. You know, I'm a lawyer, and basically the president has lawyers that are working with him as well. And it is never a sin if a president makes a mistake. And in this wise, it must have been advised by the Attorney General of the Federation, advised by lawyers that are working with the Attorney General of the Federation. He has made, if you look at it, this is Executive Order number 10. Apparently, he must have made 1, 2, 3, 4, 5, 9, and all whatnot. And apparently, if all of these were made in good faith and they were not subjected to judicial interpretation to determine whether they are good or not, apparently they are not adverse to to what we have on ground. They are not adverse to the system. They are not adverse. They are not against the spirit of the Constitution. But in this wise, yes, if you put together 10 lawyers, just like as we speak now, we had 7 justices of the Supreme Court that looked into the matter, that determined. One said yes, the executive order was in order. The executive order number 10 was in order. Apparently, it was validly made. 6 others said it was not valid. That is the beauty of democracy. That is the beauty of our profession as lawyers. People argue for, people argue against. And apparently, basically, we don't really have to blame the president for reeling out executive order number 10, but we should appreciate the fact that he took that step, and we should appreciate the fact that we have a system in place that checks excesses of the other arms of government. And I think we should see it as the beauty of democracy, rather than apportioning blames to whoever recommended the making of executive order number 10.
Oh, but Dr. Ojo, permit me to go back, piggyback on my colleague's question, because a lot of people have been making the argument about separating the office of the Attorney General of the Federation and the Minister of Justice. That if those offices are separated, it will better serve Nigeria and democracy. Does this probably highlight the reason, highlight that particular standpoint?
Well, let me say that if I'm for the separation, personally, it is my personal view that the office of the Attorney General of the Federation and the Minister of Justice should be separated. And I tell you without missing word that even if that is done, this mistake is still a possibility. But then if we have these 2 offices manned by 2 different persons, one will be a core professional doing his job, the other will be a politician appointed to oversee a particular ministry. And I give you an instance. There was a scenario in the state of Colorado in the United States of America, but because of their law, whereby the Attorney General was different, or is still different from the Commissioner or the Minister for Justice, the minister brought out a particular order, and the Attorney General went to court and said, no, we are not in support of this. This cannot stand the test of time. And the court had to interpret. At that point in time, it was adjudged that the position taken by the Attorney General, who happened to be a court professional doing his own job not as a politician this time around, took the order of the day. So if that is the case, then basically it will augur well for our democracy, so that the Attorney General will not be in the pockets of politicians at every point in time. So I quite agree with the suggestion it has been in the offing for a very long while. But you know, politicians in Nigeria, we never really want to cede power. We don't sit with whatever, when it comes to money, when it comes to power, you really see politicians agreeing that it should be taken away from them. Ordinarily, that should be the norm, and that should be the position.
You're very right, Dr. Ojo. I want to get your temperature on the 36 state governors, how you think they feel about the judgment. I know you're a lawyer, but just to put yourself in their positions.
Well, I think basically it's not really about who is rejoicing now. It's really about there is a decision made by the court. And ordinarily, if I were to be in the position of the state governors, I would not over-rejoice. I would be more keen about the law being operated the way it should be, because Section 121(3) of the Constitution is very clear that, look, there is now a financial autonomy for the courts in the state and a financial autonomy for the state houses of assembly. I would rather be keen about ensuring that this thing is implemented. That is, the letters of the law is implemented, rather than rejoicing, because it's not about rejoicing. Yes, because the law is very clear that for the overhead costs of all these of all the justices in the states, and the overhead cost is paid directly from the revenue directly from the revenue allocation committee. So it's on first line of charge. So if that is the case, then definitely let this money go to where it should be. In fact, without being teleguided by the president, without being teleguided by anyone, bring into reality, bring into implementation the position that has been provided for in Section 121(3) of the Constitution. Yes, there are no punitive provisions there, but basically that is the position. Why? Because you all swore to uphold the Constitution of Nigeria. So why are you not upholding it? Why are you not guaranteeing the financial autonomy of the courts in your state? So rather than rejoicing, you should see this as an opportunity for you to do what is appropriate and what should be done, so that at the end of the day, you might say, yes, because the executive order number 10 has been shut down, there will be agitations. You can still be taken to court to implement. If you don't do it, there could be a challenge from other quarters, that irrespective of executive order number 10, which is basically an aberration. But we can come around to ask ourselves questions. Mr. Governor, let there be financial autonomy for the courts in your state. Let there be financial autonomy for the House of Assembly. Simple. So I don't really think, if any governor is rejoicing now, then basically he doesn't understand what he's doing.
Dr. Ojo, permit me to say that at this point in time, doesn't this all point to one particular fact, that when people say that the Constitution is a flawed document, having these things rear its ugly heads, and the Constitution, the 1999 Constitution as amended, is not adequate to pilot Nigeria into a safe future? Does this just lend credence to that particular fact?
No. Where there are certain aspects, there are certain areas, there are certain provisions in the Constitution that needs to be overhauled, that needs to be examined. But in all fairness, this Section 121(3) is even a progression from what we used to have. It's something that is commendable rather than being shut down. So I think basically for me, Section 121(3), which is self-executory, does not have flaws. That is the reason why it was not necessary for the executive arm to make further laws. Rather, let the legislative arm look at it. If this law is not being observed by the state governors, then what can we do? What can we put in place to make it more, to make it stronger than what it is now? But for me, really, there will always be amendment to our constitutions. But I think this very area of the constitution is wonderful. We can only beef it up. We can only strengthen it. So there are other places that needed to be yanked off. There are other places that needed to be overhauled. There are other places that needed to be looked at. But this very law can only be strengthened. Why is it that the governors are not obeying the spirit, the tenets, the provisions of Section 121(3) of the Constitution? But basically, looking at that should be with a view that, look, let us strengthen it so that it will become a duty apparent on the governors to obey, to observe, and if they do not do it, because it doesn't have a punitive provision now, we can look at it, add some punitive provisions to it, but it is a job for the National Assembly, not a job for the President.
All right, Dr. Kunle Ojo, Senior Advocate of Nigeria, thank you so much for joining the program and having this great discussion with us this afternoon.